Closed Bridge, Trees Down, Coalition Talk Radio. Loud and proud, outrage porn-free, civilly disobedient media broadcasting live on the worldwide Coalition Media Network. Broadcasting at the Go Local Live Broadcast Center, 90 Way Boston Street, in the heart of the city we love, Providence, Rhode Island. The naked city, the city of 1,000 stories. Folks, if you're watching this live, you know just how hideous it is. If you don't have to be out, please don't drive. There are trees down everywhere. Bridges intermittently closed because of high wind conditions. It looks like it's going to be a long night here in the capital city. If you're fortunate enough to have power, again, take a moment and charge your rechargeables, but take a moment too and stick with us tonight. We might be a slightly rain-shortened version of the Coalition tonight due to some issues with guests and transportation and connectivity. A good part of the Northeast is in and out of power. In the last hour, I've spoken with people in Washington, D.C. The Senate and the House was closed early today because of loss of power. New York is a mess. We'll be fine tomorrow, as anyone who's old enough will remember the scene after Ernest Borgnine got out of the boat from There's Got to Be a Morning After. I'll spare you that rendition. But there's lots to talk about this week. Not the least of which is possibly a generational case in front of the Supreme Court of the United States revolving around, astonishingly enough, free speech, the right to work, and really the entire establishment of the labor union community here in this country. And anyone who follows politics closely knows that then, as a result of that, if you follow the daisy chain effect, ultimately politics as they're conducted. Joining me live for the very first time is a senior member of an organization that we've grown quite fond of here in the Coalition. Of course, we're talking about the Goldwater Institute. He is, in fact, the Director of Litigation and General Counsel, and he is the spearhead of an organization that we've talked about that provocatively legislates, they litigate, they discuss, and they challenge us constantly. Despite being overtly libertarian and conservative in nature, they've won accords and accolades from no less than the New York Times, who points them out as a shining beacon amongst the chaos that's in Washington, D.C. That's my words. Of course, John Riches, welcome to the Coalition for the very first time. Thanks for joining us from sunny 70 degrees somewhere else.
Yeah. Thanks for the kind words and the introduction, and I'm sorry you're experiencing that out there. I hope everyone's safe in your viewer land. I don't miss those days as a student in Boston, and I won't describe the weather outside my window here.
Now you did law school here in Boston?
I went to actually undergrad in Boston at Boston College.
All right,
about an hour from Providence.
All right, so you're an Eagle then.
That's right.
And anyone who actually really understands Boston knows that Harvard does not run Boston. Boston College runs Boston. So
that's what we like to hear.
Absolutely. So, was I overstating the importance of this case? To me, this really has tentacles into every aspect of public life as we know it. Is it really that important?
I think so. I think it's one of the most important cases the court has heard in several terms, and the court has an opportunity now to correct a problem or to correct a mistake it made 40 years ago. Look, I mean, there's two separate things going on. The first is that the way the law exists right now in a lot of states, including Illinois, is if you want to work in the job of your choice for a government agency, you're forced to pay union dues, what they call agency fees.
Right.
And the union then takes that money and they spend it on collective bargaining. Now, as you know, collective bargaining is where a government representative sits down with another government representative and they talk about how to make government bigger. And if you disagree with that process, if you're Mark Janus, you don't have any choice but to finance it. They take money out of your paycheck to finance that process. Mm-hmm. So that forces you to pay for political positions that you may very well disagree with, namely the size and scope of government. So that's the first problem, and we talk about a couple others as well.
And the primary issue there is not the right of someone to organize collectively. It's when you look at government, you're missing that final safety valve that any important cog in capitalism has, whether it be labor, capital, or raw materials. The notion that government can fail, if government is unionized, the central issue is if they can then simultaneously grease the wheels of power and control both the workers' position as well as the management's position, government cannot fail. And as a result, we as taxpayers will always be beholden to an ever-burgeoning government. We have no control over it whatsoever, do we?
That's exactly right. And you really put your finger on the fundamental distinction between the way unions exist in the private sector, where you get a group of workers together and they might negotiate for higher pay, wages, working conditions, whatever, but there is at some point a ceiling. And at some point, businesses can fail, and they can't, at some point, pay what might be demanded of them by the unions. In the government, it's really different. Unfortunately, the government has essentially a bottomless trough from which to feed. So when they sit down at the negotiating table, it's taxpayer resources that are on the line. And I think, unfortunately, many politicians concede of that as a limitless supply of money. And that's a major problem. Of course, there's also a big difference between public unions and private unions, insofar as public unions have the advantage of being able to choose their own boss. We know that government unions are very, very, very politically active. We know they're very politically influential, and they can, through their political activities, elect a person that they then sit on the other side of the bargaining table, purportedly against, where both parties are really just advocating for larger government at the end of the day.
Right, and that's how we've faced, incredibly enough in Rhode Island, a recurring attempt to create what's called evergreen contracts, which if there was absolutely no check on power, and there is so little in Rhode Island, the concept of an evergreen contract is that if the collective bargaining process, even as stunted as it is in a public union, is not successful, you simply lock into perpetuity the existing contract. So there's absolutely no mechanism whatsoever, whether it be the quote-unquote financial failure of government or the collective bargaining process, to really stifle unchecked, out-of-control government spending. And that's how you have a situation like we do in Rhode Island, where the Senate president is literally a public unionista. And where do we go? Is there ever been any estimate to understand how much money is spent by public unions in terms of electioneering, if you will, on an annual basis? Is there any real number that you could place on that?
Well, first, I've read about this problem you have out in your state with the evergreen contracts, and that's a remarkable concept.
Yeah.
You have it good while the economy's good, and then when the economy goes bad, you also have it good. It's just totally immune from market forces,
right.
Which exacerbates another problem in the public sector, which is how do you even value this in a market context? It's almost impossible for a lot of these things. So it's a very, very different circumstance than we have in the private sector.
Right.
In terms of their political clout and activity, oh yeah, there's studies that have been done, federal, state, and local level. Public sector unions are some of the largest direct contributors when it comes to political spending. But then they also have an enormous political advantage in two other respects. They're very highly organized, so they can push information out to their members that can then go and engage in political activities. And then they have a very distinct lobbying advantage. It's the only circumstance under which one special interest is required by law to sit down and negotiate with the government or with a political representative. Mm-hmm. No other special interest gets that sort of treatment. They have to compete with other interests and argue over the proper allocation of tax dollars. But through the collective bargaining process, government unions have a exclusive seat at the table that nobody else enjoys.
So, in the words of the immortal, what could possibly go wrong?
Yeah, right.
I'll throw one out to you just for you something to chew on. Here in Rhode Island, we have something called the Carrillo Law, which was named after a former state legislator who managed to pass a law that allows, for lack of a better term, allows school boards to essentially sue into oblivion the municipality under which they kind of or allegedly serve, if in fact the financial standards of the school systems aren't met. Now, that sounds, in an altruistic alternate reality, that sounds like, well, that's a great idea to make sure that they force the town to give kids the books and things they need, when in reality, you and I know that if in fact the school board is not able to successfully negotiate against teachers unions, whatever other municipal unions exist out in zombie land, Rhode Island, then they have the right just to take the town to court. Wow. The party never ends.
Yeah, unbelievable.
So now, Mr. Janus, if you can give us a little background on him and then how this got to be. I mean, it's the notion that it's made it to the Supreme Court is kind of astonishing if you're a layman like myself. But how did we get here?
Mark Janus works for the state of Illinois. He's a child welfare worker. He didn't want to be part of his union, AFSCME. He didn't want anything to do with the union. He didn't want to be a union member. Yet, when he received his first paycheck, he was surprised to learn that $50 had been deducted from it and sent to AFSCME, to the union that he didn't want any part of. So he objected to that because he knew that AFSCME was going to use that money for all sorts of purposes. Now you should know that under existing law, unions are only supposed to use what they call agency fees, this money that they took from Mark, for collective bargaining. And the Supreme Court 40 years ago said, well, collective bargaining is okay because they have to do it. It's not necessarily political. Interestingly, agency fees for most unions account to about 89% of what regular union fees do, while collective bargaining is a tiny percentage of the time that they actually spend. So I think the unions might be coming up with funny math in a lot of these cases when they are seeking reimbursement for agency fees when it amounts to almost full fees in most cases, including in Mark's case, where his agency fees accounted to about 80% of what a regular union member would pay. In any event, what Mark argued is, and what he's arguing now, is that collective bargaining is a political process. When you sit down at the bargaining table, the union is arguing for bigger government, more benefits, more authority to act in more areas, which is a political question. All of those are political questions. And so Mark shouldn't be forced to finance political activities with which he disagrees. So he brought a claim under the First Amendment and argued that that's what we call compelled speech. He's being compelled to pay for speech with which he disagrees. And unfortunately, the Supreme Court agreed to take it up.
Now that's an interesting premise. You go after essentially a commercial relationship as a free speech issue. Now, again, as a layman, explain, if you will, how did they? Was that something he had arrived at himself? Is he working with organizations who are supporting him in his legal efforts?
Oh, yeah, he sure is. And when it comes to compelled speech, so look, I mean, all of us have free speech rights. We do right now as we're talking over the internet. But we also have a right both not to speak and not to be compelled to support speech that we disagree with. Okay. And those rights are just as strong as the right we're enjoying right now. And Mark is fortunate to have representation from some very good public interest groups, including the Illinois State Policy group out there in Chicago. So he's receiving some good pro bono legal representation as he's made his fight.
Now, this had to percolate up its way up through the court system. I would imagine. How long has he been? Are you aware? How long has he actually been fighting this? Did this have to go through appeals courts and a variety of federal courts?
It had to go through federal district court and then U.S. Court of Appeals, and then the U.S. Supreme Court is what's called a discretionary court, which means it does not have to take cases; it can agree to, and in fact, it only takes less than 1% of its cases, or less than 1% of the cases that are brought to it. So the Supreme Court agreed to take this after Mark had already exhausted his other appeals.
Right, and that's exactly my point. And again, a layman here, be gentle. I believe they call it granting certiorari.
Exactly.
So there's an agenda. There's politics. All courts, particularly appointed ones, ultimately are constituted. Much conversation during the appointment process is talked about how they're constituted. Does the legal community believe that the Supreme Court, was aggressively looking to assert itself into this situation by choosing to take this case? Is this something that they had been building up to?
Yeah, I mean, in our system, the courts they're evolutionary. They're not revolutionary. And 40 years ago, it made a mistake in a case called Abood, where it said that these agency fees were fine. They said it was fine to compel somebody to turn its money over to an organization it didn't support. And sometimes the Supreme Court looks back over its precedent and sees where it makes mistakes and decides to correct them. And, we don't know how the court's going to come out in this case, but I'm hopeful, and I think broad parts of the legal community are hopeful that certainly parts of the conservative and libertarian legal community are hopeful that the court will fix something that it got wrong all those years ago.
There was... People were the spinmeisters. People were agog watching the court take testimony on this. Both sides, and particularly teachers' unions and the professional union community, has got a lot at stake. I mean, this is if this changes, I would argue, and again, not an expert, I would argue that this has the opportunity, at least on a certain level, as it approaches unions, that Heller did have on gun rights. I mean, it's a signature generational case. How did people feel the questioning and the testimony went on this?
I think they thought, the question is generally at this level pretty tough on both sides, but the reports I read indicated that there's a big block of the court that is skeptical of this proposition that you can compel money from people to support groups that they disagree with. So there's a lot of questioning along those lines, and I think hopefully that's a good sign.
Do you think this is a kind of the traditional now official 5-4 ideological vote, or is there any sense that our court watchers feel like there could be a shift, that this might not be the standard breakdown? Are folks...
Well, a very similar case made its way up a few years back called Friedrichs, where a teacher out of California named Rebecca Friedrichs brought a very, very similar challenge to Mark's challenge. Mm-hmm. And that case ultimately was decided 4-4, which means that the lower court decision ruling against Rebecca was upheld. The only thing that changed in that case was that Justice Scalia had passed, mm-hmm. And has now been replaced by Justice Gorsuch. Mm-hmm. So if Justice Gorsuch's First Amendment jurisprudence is what it was when he was a lower court judge, there's reason to believe that he will vote very much like Justice Scalia would have in this case and would cast the tie-breaking vote. But of course, anything can happen. We don't know. Other justices could flip their votes for one reason or another. But based on what happened in Friedrichs and based on what we know of Justice Gorsuch, I think that there's reason to hope that this one will come out in favor of Mr. Janus.
And it brings up 2 points. On one hand, we all know a certain situation where a certain judge decided a fine was a tax, and that changed healthcare in the United States, permanently, and much to the chagrin of the conservative element. On the other hand, should Justice Gorsuch continue along his a long career of an ideological path, if you could put on your political hat for just a second, it's clear that during the Trump administration that there will be another Supreme Court appointment. I don't think anyone doubts that certain members of the court are in very poor health and are elderly, and no one is even the most hardened ideologue isn't rooting for that to happen. But it's clear the handwriting's on the wall. Does this have the potential then to turn the next approval process nuclear, as our former president would say? I mean, if Janus goes down in favor of conservative ideology, is everything on the table in the eyes of the political left, and will this turn into a circus of unimaginable proportions? I mean, that'll make Alito and Bork and all those look tame. What happens next?
It's tough. It's tough to speculate on that sort of thing. It's possible the Senate could change parties. It's possible that this president doesn't get another appointment. But I think you are right to observe that if he does, I think people realize the stakes are quite high right now with a court that is essentially divided 5-4. Now, of course, judicial philosophy oftentimes doesn't break down into traditional conservative, liberal positions. It can, but doesn't always. So, I think we would be hopeful that the president, assuming he gets another appointment, would appoint somebody in the mold of Justice Gorsuch, who has a long career of being dedicated to the text of the Constitution and to upholding and promoting individual rights. Mm-hmm. And sometimes conservatives might agree with the way that comes down. Most of the time, they probably would, but in the criminal law context and in some others, I think there's reason for liberals to support a judicial philosophy like that.
Well, and there's other issues that are clearly on the horizon, and one always has to wonder, precedents like this set where First Amendment rights are paramount sets the stage for example, and again, I'd be fascinated to your interpretation. You've got the FOSTA legislation that's winding its way through, and I'm not sure, have you followed that at all? That's the
no, I haven't.
That's the anti-sex trafficking law, which will, and this is something I'd love to discuss with you guys when you have a chance to sort of digest this. But there's anti-sex trafficking law, or it's being labeled as, which is going to essentially potentially criminalize the communications, and not only just the actual communications, but the platform that is used to communicate on the internet for sites like Backpage, Craigslist, even Yahoo, Yelp, anything that it might involve, well, quite frankly, the dissemination of information about a sexual transaction done for money. And so, on one hand, it seems like courts have always been very careful about their treatment of these communications platforms, whether it be AOL in its earliest days or Yahoo or any of these. They've stayed away from criminalizing the content provider, whether it be a libel situation, whether it be a criminality, because they were just a venue, a communications venue. It would be like criminalizing the phone companies for someone conducting an illegal enterprise over the phone. Right. But now the ultra-conservative elements, which I believe have been emboldened by the Trump administration, are constantly chipping away from that. And ironically, it's coming from the alleged party of liberty, the Republican Party. What is, when you start to get into these court challenges on new technology, you're right. Anything literally can happen. What was the defendant, if you will, for lack of a better term, the labor unions? What is their claim to maintain this agency? On how are they defending themselves?
Really, they made two arguments, and I'd be interested to talk about how new technology impacts free speech. But they made a couple arguments. The first is they said, well, collective bargaining isn't really a political activity. All we're doing is negotiating over wages and working conditions, and that doesn't really have any political implications. So that was their first argument. And the second is that they're required to do it. Under state law in Illinois, they have to represent every employee that's part of the contract, whether the employee is a member of the union or not. Right. So to that point, I think the response is, well, let them out. If you asked to be the collective bargaining agent, they don't want to be part of the union, so let them out. Those are kind of their primary positions.
Right, and now we've had several situations. And, obviously, I'm hearkening to local issues here that you're not in touch with, but we had several situations where the pension systems, which were under the guise and under the part of the collective bargaining agreement with unions, were failing, and negotiations were had, and arrangements were made, and you had individual union members sue to be let out of the out of the class action, out of the class, if you will, and successfully sue. But what the argument here locally when they talk about Janus, though, is that okay, these guys have benefited from these wonderful these negotiations. They benefit from these, some of these incredible contracts. Where you got cost of living increases built into pensions, and the folks in the here at the coalition, we somewhat cynically refer to the real 1% as being folks who have had their benefits and lifestyles enshrined in the form of public union contracts.
Right.
So what happens on a practical level when, say, Mr. Janus, he wins, he continues to be an employee of the great state of this. And by the way, Illinois makes Rhode Island look like Utah in terms of fiscal responsibility. Illinois is truly a basket case financially. What happened on a practical level? The question comes up from folks like us. Well, what happens then? Does Mr. Janus go out and negotiate his own contracts? That seems to be the defense that takes place, at least at the street level of this agency. What's the next step?
Well, I don't think this answer would surprise anybody who's worked in the public sector for the last 100 years. But yes, I don't know about you, but when I took my job, I negotiated my own terms and conditions of employment. Mm-hmm. And of course, the employer might have policies already in place. They might already have pay scales in place. And the employee can decide whether or not it makes sense to accept employment with that employer. So I don't know why we live in a system on the government side of things where one group gets to negotiate for everybody, whether they want that person as their negotiator or not. That seems to be a real problem. So to answer your question, yeah, I mean, I think the answer is that these people should be free to either join a union if they like or not join a union if they like. And if they don't join a union, they should be free to negotiate whatever terms and conditions of employment is acceptable to both them and their employer, just like hundreds of millions of other people do in this country.
Just like you and I.
That's right.
In the world that I live in during the day, sales, how do we get a pay raise? We sell more. That's how we get a pay raise. Folks, if you're just joining us, we've only got him on the line for a few minutes more. But on a sunny Friday night where he lives, as opposed to here in La Prave, John Richards, of course, is with the Goldwater Institute. The Goldwater Institute routinely sends their best and brightest out to the coalition and really gives a provocative look at liberty issues. Sometimes really, as we say here in New England, ham and egger issues on things that affect our daily lives and opens us up to a window of possibilities that occur routinely in the real world. GoldwaterInstitute.org is the website. We provided a link for that in the show, pre-show publicity. We'll continue to provide links to that. The Goldwater Institute website is one of those websites that you need to bookmark. Rather than, as we always say, rely on national media outlets that report on someone else's reporting, who ultimately report on someone's interpretation of someone else's reporting, you can actually get real-world interpretations of big issues like this from folks who are, I'll call it literally rocket scientists of the political and government world. Now, I'll only get you for a few more minutes, but I also want to talk about, in your biography on the site, you talk about the right to earn. And I think this is all fundamental because you and your organization provide a rather provocative look at the relationship between the individual, we call it here at the coalition, the ultimate minority, the individual's rights to earn a living, and the individual's rights to earn a living within an increasingly structured, calcified, highly classified, highly licensed permission society, I think is what one of your senior people there would call it, world that we live in now. So talk about, if you can, right to earn.
So we live in a system now where almost a quarter of all jobs, a third in some states, require an occupational license before you can work in the job of your choice. And an occupational license is a government permission slip. It's the government saying, yes, go and be a plumber or a barber or a lawyer or a cosmetologist or you name it. Now, compare that to the 1950s when only about 5% of jobs required an occupational license, and almost all of those were in the medical field. The problem with this is, one, too many things are licensed. In Louisiana, you need a license to be a florist. In Maine, your neighbor right there, you need a license to be a log scaler, which I had to look up, but that's somebody who weighs logs. I'm sure that's hard work, but that requires about 800 days of training in order for the government to give you permission to be a log scaler. Compare that to EMTs in the same state, which require about 30 days of training. EMTs can cut your throat open and put an air tube in there. So I think there's the problem that just too many things are licensed. But there's another problem, and probably even a more important one. A lot of these decisions about who can get a license and who can or who has to get a license and who doesn't have to get a license, they're made by regulatory agencies, boards and commissions that aren't accountable. They're not accountable to almost anybody. Oftentimes, they're not accountable to the governor. Oftentimes, they're not accountable to the legislature or directly accountable to the legislature. And interestingly, if their decisions are challenged in court, courts review them under the lowest standard of review possible. So let me give you a quick example. If the government tried to impair your ability to put this program on by requiring a permit or a license, and you went to court and you said, hey, the government's infringing on my free speech rights for whatever reason by requiring this permit, a court would review that under what's called strict scrutiny, which means that they turn to the government and they'd say, you better have a really good reason for doing this, and whatever restriction you used, better advance that reason. Well, when it comes to occupational licensing, when it comes to economic freedom rather than free speech, the exact opposite is true. Mm-hmm. The court basically defers to all but the most crazy, all but the most irrational of government decision making. So we wrote a bill here at the Goldwater Institute that basically did a really simple thing. It said, hey, courts, when you get these cases, treat them like you do any other case. And you don't put a thumb on the scale for the government. You don't put a thumb on the scale for the regulator. You treat these like you would any other case. And of course, what we've seen now that this is law in Arizona is that you don't get more litigation, you get less irrational regulation. You allow people to work more freely in one of the most important rights that we enjoy, which is the ability to put our own labor to use as we feel that we ought to. Mm-hmm. So we're very proud of that. We hope to export it to other states, and hopefully at the end of the day, we hope that federal courts also start to take these cases seriously.
And if you could, in the few minutes that we have left with you, one of the things I emphasize whenever folks from your organization come on, we often talk about this notion that your organization creates legislation. And I kind of refer to it as sort of plug and play, portable legislation that you can break glass, add water, and download and provide to your local state legislature to provide some level of freedom. But what if you can give folks a flavor, as since you're intimately involved in this, even as someone who's in charge really of the litigation front of the Goldwater Institute. That concept, I've tried to focus on that concept here locally, is so foreign to people. It's here in Status, Rhode Island, where only good thoughts can only emanate from your legislators. They can't possibly come from somewhere else, because they have the patent on good ideas. How does that process take place? Because ultimately, if you're importing this legislation, it's got to, what's one of the oldest cliches in the book? It's got to pass constitutional muster. So how do you folks arrive at all this? It's fascinating to me. How do you make the sausage?
Well, thanks for asking. We live in a beautiful, beautiful system where our founders were so smart to not concentrate power in any one person's hands, any one entity's hands. Power's diffuse, between the legislature, the executive, and the judiciary. And then there's yet another check where the states have their own powers through our system of federalism. And at the Goldwater Institute, we're very fortunate to work in an environment where we get to go to court and advocate for the protection of individual liberties. Mm-hmm. When we see problems in our judicial system, And when we see problems on the public policy front, we can then try and craft solutions to those and advocate for their passage at the legislature. And of course, we can take actions if we need to in the executive branch through administrative actions.
Mm-hmm.
And at the end of the day, since all power resides in the states, we're a state-based organization. We like to start with the states, and hopefully on national issues that we address, that will also drive national change, whether it's at the federal level or whether it's through the states on state levels or on state-based issues at the national level.
And this is, to me, a critical point that I want to express to people who are either libertarians in terms of the big L, they're a libertarian background, perhaps even a liberty Republican, love that word. Change, we so often focus as a movement on change having to take place at the national level. You know, when you work and you live off the national press's concept that everything is centralized to DC, which of course we as libertarian, either big L or small l, should automatically disassociate from, because really nothing should emanate from DC. It should all be fundamentally state-based. So the genius of the approach here is to simply say, okay, you know, when it necessary, there are forces that will allow us to litigate at the Supreme Court level. But real fundamental change in our society to bring back the rights of the individual, to create an environment of true liberty, needs to take place at the hyper-local or at the largest, at the state level anyway. So why not focus our resources at environments we can control, where state governments still hold a large degree of accountability to the body politic, both on a practical level as well as the notion of responsibility, as opposed to the federal government, which is hopelessly bloated, almost legalistically immune from the entreaties of the aggrieved populace. And that's why I just love what you guys do, because ultimately you're fighting a ground game that's got a much higher level of success, can leverage the successes of local activists and local elected politicians to affect real change that will essentially force the hand in Washington, and largely, in its ultimate success, someday deem Washington to be largely irrelevant, other than the original vision, which was a basic national defense, and a basic national defense, and a basic national defense. I mean, everything else is, you know, we talk about everything from the Department of Education. Everything else is a recent creation of history. Ultimately, don't we need to just dial it all back to the state and local level anyway?
I think so, yeah. I mean, I think you raised a tremendously important point. When you think about it, actually, even now, with how terrible the federal government is and how bloated it is, almost all of major decisions that impact your life and my life and your viewers' lives happen at the state and local level, almost all of them. Now, of course, the federal government does have the ability to garnish our wages for purposes that you and I might not agree with oftentimes. But a lot of the most important decisions are made at the state and local level. And then you put your finger on it. Washington is in so many ways irreparably broken. I can't even get simple things done at the federal level, let alone things that are pro-liberty, pro-individual rights. So I think more and more often we have to turn to the states in order to protect our inherent, our inalienable, our inborn liberties, rather than hoping that Washington will one day fix the problem, because I think history has shown us that that's not likely to happen.
And a return to the notion that as a people, we voluntarily consent to be governed, a consent which we have the right to ultimately withdraw at any time. Whether you use it in the form of natural rights, but these are rights that we were born with, and we're seeing that now with, whether it be on the failed war on drugs, whether it be now on what's going on. And we're going to be talking later in another segment with the head of our local ACLU about these red flag laws. And, you know, let's take a second and actually consider the rights, the constitutional rights of the individuals involved, and reintroduce two words called due process back into the formula. Any one of these number of issues which have been lost, and coming back all the way back to the Janus case, a lot of that was lost because ultimately we were able to hyper-politicize a federal and state and local workforce and put them in a position where they are either fiscally accountable, nor are they accountable on any level of performance basis, because we simply have no rights right now really to control the 18-headed hydra, which is the money. And it all ultimately ties back into the money. Their ability of public unions to engage in this, my term, not yours, is this jihad against fundamental rights on literally almost every aspect of our society, and then simultaneously point out while families are crippled, businesses are crippled by the cost that are inflicted on them by this government, and then point to the need for more government because families are crippled and they need our help. It's this circular logic which has my word, crippled this country. And that's why I continue to applaud your efforts. Again, this notion of legislation, litigation, as well as deep thought, is a set of weaponry that finally allows individual rights to be weaponized, and it's wonderful to see it actually in play through organizations like yours. How can I'll always ask you, please, shameless plug. How can folks read about your organization? How can they contribute to your organization? And is there anything quickly? I know we're almost out of time here on the horizon that you're also involved in that you want to just give a shout out to.
Well, thanks for those kind words, and thanks for all you do to promote liberty and out there. And people who are interested in our work can go to our website, www.goldwaterinstitute.org. There you'll find kind of the full range of issues we work on. And on the horizon, we operate in a number of different areas: free enterprise, regulatory reform, private property rights, healthcare, education reform. I think we're going to be looking more and more at some interesting regulatory reforms and how to prevent a situation where government doesn't get to always have its thumb on the scale, whether it's taking enforcement actions against people or whether it's challenging their decisions in court, how to get it back to a system where individuals have fundamental due process rights and their fair day when government's on the other side of the coin. So I think we'll be looking at a lot of issues like that in the coming months and ahead.
Well, again, thank you so much for joining us this evening. John Riches, he is the Director of National Litigation and General Counsel to the Goldwater Institute. Of course, they can be found at goldwaterinstitute.org. Please make them part of your regular reading. If you're truly interested in affecting fundamental change, bringing America to the concept of American excellence and individual rights, these are the folks who are on the front line. They deserve your attention and your support. So thank you so very much for joining us tonight.
Thank you, Pat. Have a great day. Have a great weekend.
You too. Folks, we're going to take a quick break right now. You are, in fact, listening to The Coalition on the Worldwide Coalition Media Network, broadcasting live at the Go Local Live Broadcast Center, 90 Way Boston Street, in the heart of the city we love. Facebook.com/The Coalition Radio, on the mighty Twitter at Coalition_radio, and, of course, coalitionradio.us, where links to this and earlier programming under Coalition 1.0, when we inherited the analog world of analog radio, can be found. Just simply click on the Facebook page, on the YouTube page to see recent videos, including last week's 3-hour marathon and conversation surrounding the rights, the challenges, and the politics of decriminalizing sex work. Folks, we're going to take a quick break right now. Joining us in a few minutes is going to be none other than Stephen Brown. He's the Executive Director of the American Civil Liberties Union, the Rhode Island chapter. We are going to be talking about red flag. I'll be back in a couple of minutes to just have a general conversation. Bear with us tonight. The weather, as you know, is atrocious. If you do not have to be out, you should not be out. In my journey here from my daytime job, I saw half a dozen situations with crashed trees, crashed cars. There's a lot of flooding going on. We will survive this by tomorrow. Hopefully this will be an afterthought. There is significant power outages throughout the state. So we've got a couple of guests who are going to call in who literally have no power. So we'll be working around that and behind the scenes. But again, thanks for choosing to spend time with us this evening. Stay tuned. We'll be right back.